the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165(4) for empaneling of a bench. Then, my lords, let me not just take you through the jurisprudence of others. Then there is your own jurisprudence as this bench. "13 days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend Dr. Mudomi Thiankolu, these are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word this court mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench. You are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know. None of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you.